Well, of course, many will be wondering what are the implications going forward of this mixed decision. And to discuss that with me right now is regular contributor and correspondent Rebekah Barnett. Rebekah, thank you so much for joining us once again.
Hey, good to be here. I'm burying myself in all the breaking info on this. It's a really exciting case. I'm keen to discuss.
Well, it's
What
it's
bits do you want to talk about?
Well, it's an interesting case. I mean, we've just heard from Senator Malcolm Roberts and then from David Limbrick MP with different aspects of it. We've addressed and acknowledged the fact that this is a bit of a mixed decision. The practical effect for those who actually brought the court case is that they've, in practical terms, had a win. The precedent value is somewhat limited. But I want to talk with you firstly about the fact that this is obviously not the only court case going on. We just saw a great result in South Australia that I'll get you to tell us a bit about. And is there value in just simply chipping away and this sort of chip, chip, chip? We haven't had a final win in this case. It wasn't what we would have liked to have seen, but is there still value in this?
Well, yeah, lawyers seem to think so
Mm,
because I think lawyers tend to play a long game and build case by case by case. And whenever I've talked to lawyers like Tony Nikolic or Peter Pham or Julian Gillespie, who are all very active in this space,
mm,
they always seem to be of the view that every court case is, you're learning, you're improving, you're finding where the loopholes are,
mm.
you're building admission on admission on admission, and who knows how long it will take. But it is encouraging to see these wins trickling through because, a couple of years ago, it just felt like we couldn't get a win anywhere.
Yeah,
And the judiciary seemed to be just assuming that if the government said safe and effective and proportional, then that must be the
must be true.
bottom line.
Yeah.
Yeah, so we had the win in South Australia in the end of January. That was Daniel Shepherd. He
Mm,
won his workplace compensation claim. Essentially, the Department of Child Protection, which mandated his booster, was held liable for his injury of, I believe it was pericarditis.
mm.
And so they now are responsible for the workers' compensation for that. And it was really encouraging in that particular decision that the judge said in the decision that they didn't think that when the parliamentarians brought in the mandates, the judge said, I don't assume that those parliamentarians meant for workers to not be compensated if they
Mm,
if they get hurt.
mm,
The judge said a rational assumption would be that it was the intent of the parliamentarians that if anyone did get hurt, that they would be properly compensated under normal workplace law.
mm,
So that was encouraging because prior to that, we've seen some judgments that don't seem to be particularly rational
mm.
or kind of don't seem to follow common sense. So that was encouraging.
It's interesting to me to reflect, and you mentioned obviously not so long ago the chance of a successful court case of this nature was basically zilch. And now we're seeing
Mm.
cracks appearing. And yes, it's this particular decision from Queensland, I would argue, is a technical decision. I don't think it was won on the merits that it should have won on, in my personal opinion. But it was a win for the people that brought the case. But it's worth reflecting on the fact that we're only 2 years out from these mandates really coming in force, 2.5 years, depending on exactly where you draw that line. And it's worth thinking about the road ahead and taking that longer view, as you mentioned, that lawyers often take. Where do you think this leads in 5 to 10 years?
Well, Clive Palmer said that he would be interested in potentially funding a class action.
Mm,
So, we know he likes to stir the pot. So if he can do that by funding a few more legal suits, I'm sure he will. And I think this is such a non-answer, but it remains to be seen.
mhm,
I was encouraged by the fact that in the decision for this Supreme Court Queensland decision, I hate using the word decision, apologies, but in the decision, the judge said that the evidence had not been sufficient for the mandates that were brought in. The judge referred to footnotes being used or memos being used,
mm,
saying that, well, this has clearly been taken out of context. And the upshot was this was haphazard. It was slapped together. You're using a memo to back up breaching human rights. That's not going to cut it.
yeah,
So even though the judge didn't say you can't breach human rights, which is unfortunate,
mm,
um, at least what we got from this decision was if you want to breach human rights, you've got to put a bit more effort in. You've got to actually have references that make sense and
mm,
are in context. One at one point he said that the modelling that they'd relied on was nothing of the sort, that they did not properly consider the human rights ramifications. So that's encouraging to me, that if the government or employers want to do something as drastic as vaccine mandates, again, they're going to have to put a lot more work into it. They're going to actually really have to, make a show, which, that in a sense, it's not encouraging, because they'll probably just go through the motions. But it does mean that it will add to the effort to bring in these mandates, and it will slow the process down, because they'll have to actually, find evidence. They can't just go off the cuff like they did last time. So I think that is an outcome that's probably beneficial in a limited sense, that it will slow everything down, and it will give employers and governments pause, that they'll at least have to put more work into it if they want to do something so extreme going forward.
Well, that's the legal side of it. What impact do you think this is going to have from a public perception and public awareness side of it? I mean, I was just chatting with David Limbrick, MP, about Dr. Nick Coatsworth coming onto the morning show and kind of giving a limited mea culpa and acknowledging his own involvement in the pushing of the vaccine mandates and so forth. It was certainly a long way short of any sort of an apology, but it was a shift from what we've seen from someone like Dr. Nick Coatsworth in the past. Do you think that this decision might have a disproportionately outsized public perception impact in spite of its limited legal impact?
Maybe, but I hate to be a pessimist.
Sure.
But I think that what I learned from the pandemic period was that people are very susceptible to fear, and that by and large, Australians still like to be told what to do, and they like rules. And so even though I think that the number of people who are happy to just suck it up and be scared witless by fear and just do as they're told has shrunk, I still think it's the majority. So I think my take on it is that if the government wants to do this again, they just need a bigger threat. They just need something twice as scary or 5 times as scary. I also think that the WHO pandemic treaty and international health regulation amendments are an example of the kind of thing that give the government more cover to do this kind of thing again, but seemingly with the blessing of the global oracles that issue edicts that we all follow. So yeah, does that make sense? I don't want to be a total pessimist.
Yeah,
I just think that at the same time there are other counterforce. So yes, this was a good force in this direction, but there are also counterforces happening in this direction, and they probably at the moment cancel each other out.
Well, you're a bundle of joy, a real ray of sunshine into this situation. No, but hey, we've got to be real. We've got to be real about it. And you're not wrong. The World Health Organization and the international the new pandemic regulations are very, very concerning. And you're absolutely right. They will get used by local politicians, by Australian politicians, as cover, as an excuse to then carry out whatever it is that they want to do next time around. But there are other court cases ongoing in Australia as well. There are people pushing back on different aspects. And there is, of course, the liability aspect, which we touched on with that South Australian court case, where obviously the pharmaceutical companies have made deals with the government to say, well, we're not liable for anyone that gets harmed. The employers thought that they weren't going to be liable, and the government has certainly been careful to make itself not liable. And now all of a sudden the employers are finding out, oh, hang on, we are liable. So these court cases can still have...
the middle.
Yeah. So what are some of the other cases going on? I know these things can take a very, very long time, but just remind us of what else is in this landscape at the moment that we can look forward to at some point in the future.
Yeah, so there's that case that's in the federal court at the moment about the GMO status of the mRNA vaccine. So Dr. Julian Fidge, who's a Victorian pharmacist and doctor, he's seeking an injunction to stop the vaccines from being distributed in Australia on the basis that they're GMOs or contain GMOs, genetically modified organisms, and that those have been not properly approved by the Office of the Gene Technology Regulator. Now, the inference there is if they contain GMOs that are produced with gene technology, then by deduction, they're a gene therapy. So there's a lot riding on this for the OGTR, which is the Office of the Gene Technology Regulator, to fight this tooth and nail, because if they lose, it kind of has a lot of knock-on effects for them.
Yeah.
I mean, imagine that in the paper that, oh, this gene therapy wasn't properly approved. So we yet to see, I mean, that's been filed. We yet to see any development with that because these things are slow and take forever.
Sure.
But we know that the Office of there was actually a really interesting slip of the tongue. Dr. Raj Bueller, who's the head of the OGTR, said in the Senate late last year in a hearing, she admitted that gene technology had been used in making the mRNA vaccines. But then she said, caveat, because they weren't manufactured here, they're not under our purview and they didn't need an approval with us. Now, that runs counter to the OGTR's own documents. That runs counter to what the Gene Technology Act actually says. So we'll see what happens with that. Court. There's also the class action that Dr. Melissa McCann is running. And again, that's been filed, but the machinations are now in progress. And again, it's slow. They've got over 1,000 members. And there's a second class action in the works that I know of as well that has not yet been filed, but is in the development stage. And the difference between those two class actions is whereas Mel McCann's is targeting particularly the more like the federal health minister, CHO, Chief Medical Officer, CMO, the TGA saying, you shouldn't have approved this or you didn't go through the proper processes. The class action that's in development, which is also seeking to enroll thousands of injured Australians, is going to be targeting state CHOs and premiers, which I think there's a lot of appetite amongst people who are injured for that, because for them, the people who mandated them were the state leaders and the people who got on the television and told them they were an idiot if they didn't, or that they're an anti-vaxxer for saying they got hurt. They were the state figures. So I'm looking forward to seeing how that one develops. I think by the end of the year, we should see that one filed.
Yeah, the tragedy is you're not wrong. These things do take a very long time. They take an enormous amount of money. I mean, just the criminal charges that they held over my head took 2.5 years to play out, and that was an incredibly basic court case in comparison to any of this stuff. The process is the punishment, unfortunately, and I think what's important is that we take the wins that we can get, as mixed as they may be, as imperfect as they may be, and we just acknowledge the fact that as time passes, we are going to be able to get more and more wins, and we are going to get more and more acknowledgements of the wrong that was done. And if we don't give up, we may eventually get to the point where we can actually get a proper acknowledgement of what was done and maybe even some accountability. But if we do give up, then of course we'll never get there. So it's a matter of just persevering. Well, Rebekah Barnett, sorry.
I know I sound pessimistic, but when I said before that it's like one thing's kind of, there's a force in this direction with the win and then there's counter forces. I think the importance of these wins is if you don't have any counter force, you just get flattened.
Correct.
So I don't want to sound like I don't think it's a great thing. I 100% do. I'm just also mindful that it doesn't necessarily mean that, now we're just going to win court cases left, right and centre and this will never happen again.
Yeah, and it certainly hasn't set a precedent that's going to transform things elsewhere in Australia. Look, here at the Aussie Wire, we're all about truth, freedom and hope. We're never going to sell you false hope. We're always going to tell you the truth. And the truth is, this is a good result for the individuals that brought the court case. It's a mixed result for everybody else. We're not even sure necessarily whether this precedent is going to help the types of healthcare workers that were also mandated that weren't parties to the court case. So we've got to wait and see a lot of those details. As always, we'll stay across this story. We'll stay up to date with this and any other court cases that arise. And Rebekah Barnett, thank you so much for joining us on the Aussie Wire.
Thanks, Topher.